Good afternoon. As Roger mentioned before the break, TCSP licensees have to comply with the CDD and record-keeping requirements, as well as the other statutory AML CTF requirements. In this part, I will focus on talking more about these requirements and also highlights the more important provisions. First of all, if you wonder why TCSP licensees are required to comply with the CDD and record-keeping requirements under the AML, then I would like to draw your attention to Section 5A, subsection 5 of the AML. And under this section, the AML CTF requirements set out in Schedule 2 to the AML applies to TCSP licensees when, by way of business, the licensees in Hong Kong prepares for or carry out for a client a transaction concerning a trust or company service. The term trust or company service is actually defined in Section 1 of Schedule 1 to the AML, which basically covers the services of forming corporations and acting as the director or secretary of a corporation, and providing the registered office, and also acting as a trustee of an express trust or nominee shareholder, as well as providing a registered office. Schedule 2 to the AML contains the CDD and record-keeping requirements applicable to TCSP licensees. The CDD measures under Section 2 of the Schedule 2 are identifying the customer and verifying the customer's identity, and identify if there is a beneficial owner of the customer, then the TCSP licensee needs to identify and verify the identity of such beneficial owners. They need to take reasonable measures to verify the beneficial owner's identity, and also obtain information on the purpose and intended nature of the business relationship between the TCSP licensees and the customer. And in case where a person proposes to act on behalf of a customer, then the licensees have to identify that person and also take reasonable measures to verify that person's identities, and as well as to verify that person's authority to act on behalf of the customer. Please refer to Chapter 5 of our AML Guidelines for further details. And in particular, you should also check the appendices of our guidelines, which provides some guidance for the identification and verification of different types of customer and beneficial owners. For example, where the customer is an individual or the customer is a trust or a corporation, you need to obtain different types of documents. So please refer to the appendices. When do you need to carry out CDD? Pursuant to Section 3 of Schedule 2, TCSP licensees must carry out CDD measures under 4 situations. The first situation is when the TCSP, before they establish a business relationship with a customer, and also before carrying out for the customer an occasional transaction involving an amount equal to or above 100,000 Hong Kong dollars. And also when the TCSP licensees suspects that the customer or the customer's account is involved in money laundering or terrorist financing. And the last situation is when the licensee doubts the veracity or adequacy of any information previously obtained for the purpose of identifying and verifying the customer, or for the purpose of verifying the customer's identities. The licensee must also carry out CDD measures. Please note that if CDD measures are not carried out, the requirements are not complied with, the licensee must not establish a business relationship or carry out an occasional transaction with that customer. Even in the case when the TCSP licensee has already established a business relationship with that customer, such business relationship must be terminated as soon as reasonably practicable. And apart from carrying out CDD measures on new customers, actually in Section 6 of Schedule 2 of the AML, under which the TCSP licensee are also required to carry out CDD on pre-existing customers. Pre-existing customers means the customer with whom the business relationship was established before the Anti-Money Laundering and Counter-Terrorist Financing Financial Institutions Amendment Ordinance came into effect on the 1st of March last year. The situations include where a transaction which, by virtue of the amount or nature, unusual or suspicious, or is not consistent with the licensee's knowledge of the customer or the business risk profile or source of funds of the customer. If the licensee is unable to carry out CDD in such situation, the business relationship with the customer must be terminated as soon as reasonably practicable. After carrying out CDD measures as mentioned, ongoing monitoring is also a very important part of an effective AML CTF system. The TCSP licensee must review from time to time the documents, data, and information relating to the customer, and to make sure that they are up to date and relevant. And also, they need to conduct appropriate scrutiny of transactions carried out for the customer to ensure that they are consistent with the licensee's knowledge of the customers and also the customer's business and risk profile, and also with the licensee's knowledge of the source of funds of the customer. And also, the licensees have to identify transactions that are complex, unusually large in amount, or of an unusual pattern, or that have no apparent economic or lawful purpose, as well as examining the background and purposes of those transactions and setting out the findings in writing. TCSP licensees have to note that these requirements for ongoing monitoring apply to pre-existing customer as well. In certain situations, TCSP licensees are required to take additional measures as enhanced CDD. That is what we call EDD. Please remember that the EDD requirements are actually in addition to additional to the CDD requirements. So you still need to carry out CDD requirements, but you just need to carry out more requirements in such situations. The high-risk situations for which EDD apply include the situations where the customer is not physically present for identification purposes, and also where the customer or the beneficial owner of the customer is a politically exposed person, and also in any situation specified by the registrar in a notice given to the licensee, and also in any situations that may, by virtue, may present a high risk of money laundering or terrorist financing. For example, where the customer is from or the transaction is connected with a jurisdiction that does not or insufficiently adopts the FATF Act requirements. Or another example is where the corporate customer has issued some bearer shares. These are the high-risk situations that you need to be aware of and need to carry out the EDD measures. For the first situation that I just mentioned, where the customer is not physically present for identification purposes. The TCSP licensee must at least further verify the customer's identity and also take supplementary measures to verify information relating to the customer that has been obtained by the TCSP licensee, or ensure that the first payment made in relation to the customer's account is carried out through an account in the customer name with an authorized institution, that is a bank in Hong Kong, or a bank operating in an equivalent jurisdiction that has measures in place to ensure compliance with requirements that are similar to what we have imposed under the Schedule 2 to the AML, and is supervised for compliance with those requirements by a banking regulator in that jurisdiction. For the second situation that I just mentioned, and where the TCSP licensee knows from publicly known information or information in the licensee's possession that the customer or the beneficial owner of the customers is a politically exposed person, before establishing a business relationship with that customer, or before continuing the business relationship where the customer or beneficial owner is subsequently found to be a PEP, a politically exposed person, then the licensee must obtain approval from its senior management and also take reasonable measures to establish the customer's or the beneficial owner's source of wealth and source of funds. Further, as I've just mentioned, pursuant to Section 15 of the AML, of the Schedule 2 of the AML, a TCSP licensee must also carry out EDD in situations specified by the registrar in the notice given to the licensee, and also in situations that may present a high risk of money laundering or terrorist financing. Such examples I've just mentioned are also given in our guidelines, in Chapter 4 of our guidelines, so you can refer to it for more details. And in such situations, the licensee should also obtain approval from its senior management to establish the business relationship or to continue the relationship, and also either take reasonable measures to establish the customers or the beneficial owners' source of wealth and the source of funds, or take additional measures to mitigate the risk of money laundering or terrorist financing involved. Apart from CDD, record keeping is another important aspect under the AML. TCSP licensee must comply with the record keeping requirements in relation to each transaction and each customer. For each transaction, the licensee has to keep the original or copy of the documents and a record of the data and information obtained for at least 5 years from the day on which the transaction is completed. Whereas for each customer, the licensee has to keep the original or copy of the documents and a record of the data and information obtained in the course of identifying and verifying the customer or the beneficial owner, and as well as the original or copy of the files relating to the customer's accounts and the business correspondence. Such records of the customers and must be kept throughout the business relationship with the customer and for at least 5 years after the date from which the business relationship ends. As mentioned by Roger before the break, besides the AML, there are other legislations in Hong Kong that are concerned with money laundering, terrorist financing, financial sanction, financing of proliferation of weapons of mass destruction, and also in relation to the obligation to report suspicious transactions. Insofar as financial sanction is concerned, the chief executive may makes regulations under the United Nations Sanction Ordinance to implement sanctions, including targeted financial sanctions against certain persons and entities designated by the Security Council of the United Nations. The chief executive may, by notice published in the Gazette, or by publishing on the website of the Commerce and Economic Development Bureau, specify a list of persons and entities as relevant persons or relevant entities. Such lists may include persons or entities designated by the Security Council of the United Nations or its sanctions committees for the purposes of financial sanctions. Please note that it is an offense for any person to make available any funds or other financial assets or economic resources to or for the benefit of the relevant persons or relevant entities, or to deal with any funds, other financial assets of economic resources belonging to or owned or controlled by such persons or entities, except under the authority of a license granted by the chief executive. In relation to terrorist financing, you may wish to know that FATF has a definition for the term terrorist financing, and according to which TF means the financing of terrorist acts and the financing of terrorists and terrorist organizations. It generally refers to the carrying out of transactions involving property owned by terrorists or terrorist organizations, or that has been or intended to be used to assist the commission of terrorist acts. The term terrorist financing is actually also defined in Section 1 of Schedule 1 to the AML to cover the provision or collection of property to commit terrorist acts, or the making available to any property or financial related services to a person knowing that such person is a terrorist or terrorist associate. As Ms. Learn has also mentioned before the break, the United Nations Antiterrorism Measures Ordinance criminalizes the provision or collection of properties and making any property or financial or related services available to the terrorists or terrorist associates. The highest penalty, may I remind you again, for the offense upon conviction is imprisonment for 14 years and a fine. And the ordinance actually also permits terrorist property to be frozen as well. And let me also update you a little bit about the ordinance. The amendments to the ordinance came into operation in May last year to further prohibit any person from dealing with specified terrorist property and property of a specified terrorist or terrorist associate, as well as to prohibit the financing of the travel of a person between states for the purposes of perpetration, planning or preparation of or participation in terrorist acts, or the provision or receiving of terrorist financing, terrorist training under section 8A and 11L of the ordinance respectively. So, please also refer to Chapter 8 of our AML Guidelines, which sets out the requirements under the other relevant provisions in the ordinance and other requirements in relation to the terrorist financing. As Roger pointed out, these legal requirements apply to all persons, including the TCSP licensees. please be reminded not to have any business relationship with any relevant person or relevant entity which are subject to financial sanctions, or any terrorists or terrorist associates. Actually, all TCSP licensees are required to ensure that they have an appropriate system in place to conduct name checks against the list of such persons and entities in the course of carrying out the CDD procedures. Please check out our TCSP website for the list of persons and entities who are subject to the to financial sanctions under the United Nations Sanctions Ordinance, and also the list of persons designated as terrorists or terrorist associated as specified under the United Nations Antiterrorism Measures Ordinance. When such list of persons and entities are updated, we will notify the TCSP licensees by email so that the licensees can take prompt actions to ensure compliance with these requirements. In relation to PF, the counter-financing of proliferation of weapons of mass destruction, please pay particular attention to the provisions of the Weapons of Mass Destruction Control of Provision of Services Ordinance, and as well as the regulations made under the United Nations Sanction Ordinance, which implement sanctions against Democratic People's Republic of Korea and Iran. Activities, transactions, or relationships that are suspected to be related to weapons of mass destruction, proliferators should be handled with great caution, as it is an offense under Section 4 of the Weapons of Mass Destruction Ordinance to provide any service to another person where he believes or suspects that those services may be connected to PF. The ordinance prohibits the provision of services that may assist the development, production, acquisition, or stockpiling of weapons of mass destruction in Hong Kong or elsewhere. The provision of service covers a wide range of activities and includes the lending of money or other provision of financial assistance. For this slide, I think I will just briefly go through this slide as Ms. Leung will cover this topic in detail in her presentation in the next session. But let me first repeat what Ms. Leung has mentioned before the break, as it is very important to remember that according to Section 25A of the Drug Trafficking Recovery of Process Ordinance and the Organized and Serious Crimes Ordinance, it is an offense for a person who fails to disclose his knowledge or suspicion of any property that represents a person's process of drug trafficking, an indictable offense, and where it is a property which is terrorist property. Sorry, I forgot to mention also the Section 12 of the United Nations Antiterrorism Measures Ordinance. Please look at Section 2 in detail. As this offense, as Ms. Leung mentioned, is carried a maximum term of imprisonment of 3 months and a fine of 50,000 Hong Kong dollars upon conviction. So TCSP licensee reminded that in cases of suspicious of money laundering, terrorist financing, PF, or sanction violations, please make a report to JFIU. You may also refer to Chapter 7 of our AML Guidelines for the relevant requirements to report suspicious transactions. This is the end of my presentation. We hope that you now have a better understanding of the TCSP regime as well as the AML CTF requirements.